We have the first question from Teresa. She says she needs help. We are currently renting a home that is full of damp issues. The owner is not wanting to fix this. We want to move out as it is a real concern, but the lease only ends in August. She is saying she won't give us our deposit back. What is the law pertaining to this situation?
Okay, it's easy enough actually. Damp isn't really a crisis for a tenant as long as you inform the landlord. Remember, if you have a damp issue and at the time of taking occupation there wasn't a damp issue, now suddenly there is a damp issue and you didn't inform the landlord can say, okay, but you didn't tell me about the damp issue. So the extended damage now caused because of the damp and the fact that you didn't inform me about it now becomes a tenant responsibility, and it could be a damages claim the tenant has against the landlord has against the tenant. However, in the context of this question, I can clearly hear the landlord was informed of this, but damp doesn't really easily cause chaos to a tenant's life. You can live around damp. If it's only until August, it's not a crisis situation. If it is damp to the point where it's creating a black mold situation, which is obviously causing a health risk, now it's something else. Or if it's damp, and I've seen this, I have seen like damp to the point where damp gets into cupboards and it mold into the clothes and stuff like that. But I mean, by the time that happens, you could have already enforced your rights as a tenant. You do not have the right to just vacate. You need to place the landlord on terms, because if you inform the landlord of this problem and the landlord's not doing anything, as much as the landlord can't just enforce his rights against the tenant that doesn't pay his rent. I mean, when a tenant doesn't pay rent, we can't just walk in and kick the tenant out. What do we need to do? We need to place the tenant on terms, give him 20 business days to remedy his breach or whichever relevant time period. And only if he doesn't remedy his breach can we cancel and then evict the tenant if he doesn't vacate on own accord. But the same goes to the landlord. If the landlord is notified of damage that has to be repaired by the landlord, for instance, I mean, damp is always going to be a fair wear and tear issue, unless the tenant does something funny like putting a swimming pool in a rubber plastic swimming pool on the second floor. If it's not a tenant thing, if it's in fact a damp issue caused by the building foundations or the roof not being sealed proper, landlord obligation. But you can't just be like, okay, Mr. Landlord, you didn't fix this, so I'm out, cheers. You don't have that right. Also, don't cancel in terms of section 14 of the CPA, or for the leaseback users, clause 21 of the leaseback. Make sure that you are actually then placing the landlord on terms. Give him a time period to remedy the breach, a reasonable time period. 7 days might be a bit short for damp. Give him 20 business days or whatever to repair that. And tell the landlord, if you don't repair it, Mr. Landlord, I am going to cancel this agreement and then claim damages from you. So do it properly. Place him on terms, and if he doesn't repair, then you can cancel and claim damages or enforce specific performance. But you can't just vacate. Then you would be entitled to the rights in terms of the Rent Housing Act, saying that if you abscond, well, that's going to be basically absconsion, you would be entitled to all damages that he suffered as a result of that.